What's up, everybody? Welcome back into another episode of The Lawyer You Know. And while we've already hit a slew of the filings that have just come down the pipe in Karen Read's case, as we're coming up on the trial today, in this video, we are going to go through the most highly requested documents I did not hit in part one, and we're going to go into detail. We're going to read most of them. We're going to summarize maybe some of them, discuss how they could affect trial number two, and what we think Judge Cannoni is going to do. So everybody hit that like button. And let's get into it. So this is not overly abnormal to have all of these filings come in over the last couple of weeks. We talk about all the time for no real reason except that lawyers are busy. And if judges don't hold lawyers accountable until the deadlines hit, nobody does anything or nobody actually turns anything over, which is exactly what's happening here, right? All the deadlines are hitting, so all the documents are coming in. We are going to see things come in after the deadline. We are going to see arguments made that things are late. We are going to see issues that pop up before trial that the judge is going to give some grace on and still discuss, because just like last time, she is going to want this trial to push forward on April 1st. It's also really important to discuss that this is all the work that needs to be done when prepping for trial. This is how much work is out there for these lawyers to do. So when you have unnecessary motions, unnecessary hearings, name calling back and forth, fighting for your reputation back and forth, it takes a lot of time and, dare I say, wastes a lot of time if it's unnecessary, which again is part of a judge's job to make sure that unnecessary wastes of time don't occur, to make it more difficult for these lawyers to prep for trial, because especially the defense attorneys, they have other cases they're working on. This is not the only case. Now, there's a lot of attorneys, thank God, working on it, but if there was only one, I don't see how they can really handle any other cases at this point as we're getting close to trial. And I apologize for being late for this video, because speaking of lawyers and things happening, I had a call that went long and it just pushed me to be a little bit late for this video, but we're here now, and we're going to start and end with probably my two favorite filings. So the first one that we're going to start with, which I think may have been definitely top 2 or 3 most requested documents to go over, is the defendant's motion in limine to allow counsel to state grounds for objections to promote judicial economy and efficiency and adequately preserve issues. So while this is something that we all wanted, that seems like second nature to anybody that's a lawyer out there listening or has watched other trials other than the Karen Read trial, is they just say objection. They don't say anything else. I don't really get it. What are we supposed to do? What are they objecting to? What if Judge Cannoni doesn't know what they're objecting to? How can you make arguments? All those issues, while very legitimate, I agree with 100%. I hate that they didn't do it in the first trial. But what I will say is, this is not something that's going to be a surprise to Judge Cannoni. It's not like she hasn't thought about this. It's not like she and they, the collective they, don't know how it's done around the country. So while it's not really a surprise, it's still an interesting motion that I want to read here together with you. I haven't read all of these. I've read some of them, not all of them. Some of them I saved that we can just read together, react to together. All right. Now comes Karen Read, respectfully move the court in limine to allow both parties to state the grounds. Okay, it's just a repeat of the title. As grounds for this motion, Ms. Read states the court's general order that counsel not state grounds for their respective objections before the jury led to extensive discussions at sidebar, which lengthened an already extensive jury trial. Ms. Read further states that the inability of defense counsel to state grounds for objection could lead to their inability to preserve issues and issues for any necessary appeal. Stating the basis for an objection in a word or two will not cause either side any prejudice. So not only will it not cause either side prejudice, but sometimes juries start to guess, whose fault is it that we have another sidebar? Why does the defense keep objecting and then we have a sidebar? It's delaying it. Jurors always think and wonder what's going on at that sidebar. What are you guys talking about? So that can create some prejudice, and 1 or 2 words really shouldn't, and they need to keep it tight, no speaking objections, but at least be able to give grounds. However, I've never had a trial like this, but welcome Linda Howard, new subscriber. But I would have to imagine on appeal that the fact the judge would not allow you to put a basis, you would be able to argue to the appellate court any basis you can think of after the trial even. Like, I was objecting for this, regardless of what you thought at the time. Whatever the best objection is something you should be able to argue on appeal, in my opinion, if the judge is not going to allow you to give grounds. While Ms. Reed acknowledges that generally considerations of judicial economy must yield to the defendant's right of a fair trial, in this instance, it is the defendant making this request. Massachusetts courts and the Rule of Criminal Procedure have outlined several scenarios that demonstrate the general promotion of an interest in judicial economy and efficiency. For example, the SJC has noted that joinder under Mass Criminal Rule 9 may promote the economics of adjudication of criminal offenses. Additionally, the Supreme Judicial Court condoned the practice of taking motions for mistrial made during closing arguments under advisement until after the return of the jury verdict to promote judicial economy and efficiency and to preserve the valuable judicial resources by obviating the need for a retrial should the jury return a verdict of an acquittal. So you don't need to do that motion if the defense is going to win anyway. So let's just save time, put it in the jury's hand. Don't let the judge make that decision. Basically, whenever they talk about judicial economy, make things run smoother, take up less time, take up less resources, take up less money for the citizens. Finally, judicial economy was explicitly cited as a consideration by the SJC in eliminating the so-called power of resurrection in criminal cases, noting there are many rationales for the raise or waive rule, that it is necessary. It is a necessary corollary of our adversarial system in which issues are framed by the litigants and presented to a court. That fairness to all parties requires a litigant to advance his contentions at a time when there is an opportunity to respond to them factually. If his opponent chooses to, the rule promotes efficient trial proceedings. That reversing for error not preserved permits the losing side to second guess its tactical decisions after they do not produce the desired result, and that there is something unseemly about telling a lower court it was wrong when it never was presented with the opportunity to be right. The principal rationale, however, is judicial economy. There are two components to judicial economy. One, if the losing side can obtain an appellate reversal because of error not objected to, the parties and public are put to the expense of retrial that could have been avoided had an objection been made. And two, if an issue had been raised in the trial court, it could have been resolved there, and the parties and public would be spared the expense of an appeal. Related to the now, and that's why I always say, when one side says, oh, you can appeal it, or oh, they'll just appeal it. It's like, yeah, nobody really wants that. It's not good for anybody. It just keeps the case going forever and ever. Related to the now defunct power of resurrection doctrine, the failure of counsel to state grounds has, in at least one instance discovered by undersigned counsel, led to an appellate court holding that counsel failed to preserve an issue. Oh, here we go. In an unpublished decision, the appellate court of Massachusetts outlined a scenario that could easily recur in this matter, absence of allowance, this motion in limine. The most hotly contested issue at trial was the identity of the shooter. The Commonwealth sought to establish the defendant's identity in part by introducing a security video of the shooting that showed the shooter wearing a white t-shirt and eliciting evidence that that was what the defendant habitually wore. This evidence consisted of testimony to that effect from a percipient witness, Erica Moody, a police officer, Kevin Swan, who was familiar with the defendant, and a police detective, Kevin Dugan, who had participated in the investigation and had viewed the defendant's social media pages. Dugan also authenticated 2 social media photographs of the defendant while wearing a white t-shirt. The defendants argue on appeal that this was inadmissible habit evidence. The parties disputed the standard of review with respect to the habit testimony. The defendant argues that the issue was preserved and that the standard of review is for prejudicial error. The Commonwealth argues it was not, and that the standard of review is for a substantial risk of a miscarriage of justice. We agree with the Commonwealth. The prosecutor twice asked Swan whether the defendant typically wore the particular type of clothing. Defense counsel objected to the first question without stating his grounds, and the judge stated, sustained as to foundation. The prosecutor immediately laid the foundation and asked the question a second time. Defense counsel again objected without stating his grounds, and the judge overruled the objection. In these circumstances, it is clear that the overruled objection was based on foundation, which is insufficient to preserve an objection on habit grounds. While defense counsel objected at sidebar shortly before Dugan's testimony, the objection was only as to the introduction of the photographs, not Dugan's testimony, and was on cumulative grounds, which is also insufficient to preserve the issue for appeal. There was no objection at all to Moody's testimony. So here's my issue. Overall, I 100% agree with the defense that you should be able to state your grounds for your objection. It just makes sense. That's what trial lawyers do. That's how we protect the record. This seems like a very easy call, although based on what happened in the first trial, I think it's going to be an easy call in the opposite direction for Judge Cannoni. But this case cited by the defense, I do think Judge Cannoni would say that how they handled it in the first trial would fix this issue in the way that Judge Cannoni would say, let's have a sidebar. Any other issue on this objection besides foundation that we need to talk about, defense counsel, and they can have that argument at sidebar. So from my perspective, potentially Judge Cannoni is going to be able to find a workaround then to just be able to allow them to state their grounds on the record, which I think is incorrect. I think they should state their grounds on the record and not have to go to sidebar every time. This always brings me back to my COVID trial that I had in masks with COVID, with plastic up, separating the jurors far apart, weird courtroom setup. Ended up being a great result, but I always think could it have been better if it was not during COVID. And every time we had to have a sidebar, we had to go off into the hallway and we had to be 6 feet away from the judge. And I had to help carry the stenographer. I didn't have to. I wanted to help carry the stenographer's, all of her equipment because I felt so bad that I was the one doing a lot of the objecting and making these arguments. And I didn't want the jury to think I was some jerk making this trial last forever. So all these sidebars, you have to think about these issues when you're the lawyers they're looking at. And honestly, this happens more for criminal defense lawyers. And then on civil side, both lawyers, because you're looked at as the chosen lawyers for that party. Doesn't hit the state quite as much as, government lawyers. But it is something you have to think about. You don't want the jury to hate you. That obviously does not do well for you as a trial lawyer. Put simply, defense counsel's failure to state the grounds for his objection, one, led the appeals court to infer the grounds for his objection. So, and that's the problem. If they're really going to infer, they need to infer everything, every possible objection that could be made. I'd have to read this case because there's a lot of nuance. There's a lot of it depends as far as it goes with this case they cited, in my opinion. Number two, and having done so to determine that the defendant was entitled to a less deferential standard of review to which he would otherwise have been entitled had the correct issue been preserved. Although the court went on to say that even if the court had applied the more deferential prejudicial error standard, which it did not, the court would still have determined that the error did not influence the jury or had but very slight effect. More important than the specific facts of the case, however, is the fact that the appeals court agreed with the Commonwealth that because the defense had failed to adequately preserve the issue, because he failed to state the correct grounds for the objection, the standard of review on appeal would be less favorable to the defendant, substantial miscarriage of justice. So to me, never really makes sense. They need to allow the grounds for the objection. It's the only way that it should be done. It is, in fact, it does just affect the trial in the way that you try a case. Shannon Kay said, how does not allowing the state stating of the grounds benefit Bev? I don't think it's about benefiting her, right? I really don't. I think it's a smoother case. We have on this channel, and myself included, been very annoyed when lawyers give speaking objections and they argue the case in front of the jury. So from my perspective, she cuts that out altogether. So it's a cleaner, smoother case in front of the jury. You don't have to worry about prejudicial arguments being made in front of the jury, which we've seen in other cases, and it's been very horrible and annoying. So that's a benefit to everybody, not just Judge Cannoni. And I think that's just the way that she does it. I don't think she does this to hurt one side or the other. And my guess is Hank Brennan would be perfectly fine stating his grounds for objections as well. AV to the seventh power. Welcome to the membership crew and excited just getting into this case. Thanks, Peter. Oh, good luck. Welcome and good luck, as they say. Happy to have you, pumped that you are here. All right. Since the ability to state the grounds of objections will both, one, further the interest of the court and the public in judicial economy and the efficient interest of justice. Two, will avoid the possibility of failure by counsel to have the ability to adequately preserve any possible issue for a necessary appeal. And three, would cause prejudice to neither party. Ms. Reed respectfully requests the counsel for both sides be allowed to state their grounds for their objections. What's interesting about this as well is now that they've made this motion, I would hazard a guess that if this comes up on appeal, they're going to say, Judge, this is exactly why we wanted to have this issue handled this way, and the judge refused to allow us. So therefore, we should have the benefit of the doubt in being able to state multiple grounds for objections that we would have made at the time because the judge did not allow us to make those objections. How would the appellate court look at that? Only they know. Miraculous Hufflepuff, currently catching up on the video from last night to be up to date for this live. Yes, we are going to link that video, I think either in the comments, a pinned comment, or maybe in the chat. We will We will make sure you guys have that link so you can go check out all the other filings I looked at. I'm not going to get to all 30, but probably somewhere in the 15 to 20 range when it's all said and done that we looked at here. Bodie said, Peter, is she doing this to lessen the number of objections? I mean, I'll just tell you, for myself, this would not lessen the amount of time I'm objecting. This would just probably frustrate the jury with more sidebars. Here's the point. As annoying as it was to have every sidebar in the hallway, I didn't bite my tongue. I didn't not object a single time that I felt like I needed to object, because when you do that, you don't know what a jury's going to do. You have to protect everything. You have to assume the worst. That's basically what I do. I was on the phone during that trial with appellate counsel because I think the court let in some things that they shouldn't have let in. I was like, if they give us a bad number on this case, we're going to appeal. I need you to come help me in appeal, because it was a lawyer that I was friends with that had this expert on another case. And I was doing that literally in the hallway in the middle of trial, and we ended up doing great. So you always plan for the worst. So I don't think it's going to affect the way the defense attorneys object. I don't think they're going to bite their tongue. Shout out to AV and TLA, the lead attorney. Oh, what's up? Is the lead attorney in here? That's cool. If he is, what's up? If he's just getting into this case as well with AV, welcome aboard. Jump on in. The water's nice. Okay, let's get to the next one. I don't think I have this full motion, so I'll just kind of give you my summary, but I wanted to mention, this is something I want to mention. The Commonwealth also wants to individually voir dire the venire, the potential jurors. They want to be able to ask questions as well, which I said on my prior video, if you didn't watch it, that usually good lawyers want to do that. So I would expect Hank Brennan to say he wanted to do it, but if he feels like way too comfy in his state attorney chair now, and how most jurors start on the side of the state, maybe he wouldn't, but he does in fact want to. So both sides want to individually voir dire these potential jurors. There's a lot of reasons why, a lot of media coverage, obviously. So I hope the judge grants that motion. I didn't give you what I thought the judge was going to do on the last motion, the speaking objections. This one to me would be an easy yes. You can give your not speaking objections, but grounds for objections. But number two, I could see it as a very easy no for Judge Cannoni, because she's already thought about this and didn't allow it in the first trial. So I'm going to leave that one as up in the air. I hope she allows it, but I'm not optimistic that she will. All right. The next one we are going to talk about is the Commonwealth's motion to preclude the third-party culprit defense. Let's pull that up here. So some of these, like this one, is something that was already argued on the first trial and decided on the first trial. No grounds for objections, and this one. So in order for Judge Cannoni to change her mind, something either would have had to change. She would have to have a change of heart. Maybe more evidence came forward. Maybe she changed the way she looked at certain evidence. Let's take a look at this motion. Commonwealth comes and they ask to get rid of the third-party culprit defense. The defense claim has been nebulous from its origin. Karen, just to be clear, you didn't do it. We know who did it, Steve. We know. And we know who spearheaded this cover-up. You all know. After the first trial, the position began to transform. We're going to retool everything, and maybe some things will stay some more, but we're going to shuffle a lot of things around. And then most recently on the interview we all watched together, in your opinion, there have been a few names that have surfaced as a third-party culpability theory. Who do you think? If John was beaten up and attacked in the house, who did it? Defense counsel said, we don't know. The defendant quickly echoed, we don't know. Counsel further said, and it's not for us to know. Somebody other than Karen is responsible for that, for killing John. But who is it specifically? Others know, and they're not talking. So I do agree those statements are, pretty different, but the defense is not held to any individual theory. And as more information comes in, the theories can change. And instead of them, this is really probably what happened. Instead of them thinking it was one person, maybe it was multiple people. The point is, they've always said it happened in that house. It was somebody other than Karen Reed. That has not really changed. And Hank Brennan making this argument to me is unnecessary and not the winning argument. I would just stick to what was argued last time because it was the winning argument. And he does get into some of that. The evolving responses have vacillated from an unidentified certain villain to not knowing who's responsible to have been the hallmark of the defense's third-party culprit claim since its inception. They're not entitled to engage in scorched earth tactics. Prior to the first trial, the judge made the ruling that the court ordered that based on the offer of proof on Friday, I am well within my right pursuant to the case law to exclude the third-party culprit defense. I'm not going to allow you to do that now. I'm going to give you a chance to develop it through relevant, competent, admissible evidence, but you cannot open on it. So that is my ruling. Despite the court's clear ruling, the opening statement said Karen Reed was framed. Her car never struck John O'Keefe. She did not cause his death, and that means somebody else did it. Followed by, because the Alberts were involved and because they had close connections to the investigation in this case, Karen Reed was framed for a murder she didn't commit. The evidence identifying or establishing a third-party culprit was never forthcoming throughout the trial and to this day continues to be non-existent. All right, what does the Massachusetts law say? Evidence that a third party committed the crimes charged against the defendant or had the motive, intent, and opportunity to commit the crime is admissible, provided that the evidence has substantial probative value. And that, my friends, is where judicial discretion comes in. Does this third-party culprit evidence, provided that the evidence has substantial probative value? In making this determination, the court must make a preliminary finding that the evidence is relevant, is not too remote or speculative, and will not tend to prejudice or confuse the jury. So if I'm Hank Brennan, that's the argument I'm going with. It's too remote, too speculative, it does prejudice or confuse the jury. Those are the arguments I think that were successful before. So I would just regurgitate those arguments and hope the judge makes the same ruling, because whenever you're on the side of the prior ruling that the judge already made, you want to stick there and you want to get that ruling again. That, as a lawyer, is how you look at it. If the evidence is otherwise inadmissible, the court must also find that there are substantial connecting links between the crime charge and the third party, or between the crime charge and another crime that could not have been committed by the defendant. After 3 years, the defendant has yet to provide any evidence as to whom they suggest is the third-party culprit responsible for the victim's death, or any evidence of alternate circumstances that would have caused the victim's death. The absence of an evidentiary basis to support a third-party culprit defense was clear before the start of the first trial. So a prototypical third-party defense is, you charge John Smith. We think it's John Jones. We think it's John Jones because the culprit's name is John. They both are right-handed. They're both 6'5". John Jones was also in the building when the crime was committed. John Jones has prior similar acts. John Jones had people witness that he was there. So you have that evidence connecting a specific individual with the opportunity, in the timing, could have committed the crime. This one is more vague. They have a lot of evidence that is suspect and shady and problematic and goes to the horrible investigation of the state and what happened in the house. Why did they do an investigation? The fact that we don't know is because they did a piss poor investigation. We know all that, but it is different to specific evidence of who the third party culprit is. And in my opinion, in the interest of justice, you let the defense make the claim the way they have it. They don't say it was Colin Albert or Brian Higgins or any individual person. They say something happened in that house and we can't prove it because the state did not investigate inside that house, but here are all the reasons why. And they could proffer all this evidence as to why it is more likely something happened in the house than outside, and that could be reasonable doubt. So it's a little bit different than a third-party culprit defense, but I think there is a way to let the defense present that evidence without pointing the finger at a specific person. But it's very difficult sometimes for judges to get creative. Lawyers don't have that creative side of the brain that works as much as many other professions. To accept the defendant's third-party culprit defense, the court has to find the defendant demonstrated the acts of the person are so closely connected in point in time and method of operation as to cast doubt upon the identification of the defendant as the person who committed the crime. Feels like my voice is going literally mid-video today, but we're going to push through. Therefore, the defendant would have to provide evidence of substantial probative value that another individual had the motive, intent, and opportunity to commit not only the crime, but vehicular manslaughter and leaving the scene of the crash causing death. So that's not true. You could easily just pick a third-party culprit for one of those. And I mean, the other two, I guess it is, he's conflating the issues because this is not actually what it is. You don't have to say they also committed the vehicular manslaughter, but because they committed the crime, the defendant could not have committed vehicular manslaughter or leaving the scene because this was not an accident. And here is the proof we have of that. That's how the defense would break it down. He's making it seem like a way, because they're not saying anybody else committed vehicular manslaughter, because they're not saying anybody else left the scene, they can't have a third-party culprit defense. That's just not logically how it would work. But he's a lawyer trying to make arguments. To raise a third-party culprit defense to one charge that is closely intertwined with the other charge would pose a real threat of prejudicing by confusing the jurors. Come on. It's not confusing at all. If somebody else committed the M, then the other ones didn't happen. It's not like they're saying somebody else was driving Karen Reed's car. Diverting their attention to wholly collateral matters involving persons not on trial. The defendant's right to present third-party culprit defense is not absolute. The admissions of by the way, when case law says the defendant's right to present a third-party culprit defense is not absolute, kind of like the defendant's right to choose their own counsel is not absolute, what that means is it's almost absolute. If you have to say it's not absolute, it means it's almost absolute. It really does. If you think about how they make certain arguments, some are close calls, some are gray areas, some are judicial discretion, some are must, and then right below must are the ones that you have to say are not absolute. The admission of feeble third-party culprit evidence poses a risk of unfair prejudice to the Commonwealth because it inevitably diverts jurors' attention away from the defendant on trial and onto third person, and essentially requires the Commonwealth to prove beyond a reasonable doubt that a third-party culprit did not commit the crime. You should be able to do that. You should be able to do that, right? If you've got the right person, you have all of the resources, you have law enforcement on your side, you have all the time you want, you have a special prosecutor. If you can prove Karen Reed did this beyond a reasonable doubt, that means nobody else did it. It's like, we can't take on this burden, judge, to prove that somebody else didn't commit this crime. It's like, you should be able to. What this is really supposed to protect is me saying, them saying, Peter, you did this. And I say, no, Ashley did it. It's like, why do you think Ashley did it? Because she did. I just know that she did. It's like, no, you can't do that. Can't do that. But if Ashley was here on those dates, driving the same car in the same area, and witnesses saw her at the crime scene, then maybe I can point the finger at Ashley. All right. And sorry, Ashley, I'm just kidding. Where do we got? Additionally, hearsay offered for the truth of the matter asserted that a third party is the true culprit and not within a hearsay exception may be admitted only if, in the judge's discretion, the evidence is relevant, will not tend to prejudice or confuse the jury. Let's see what else. They cite some cases of where this was appropriate. Testimony of witness that in the days prior to the crime, the victim has expressed fears about being harmed as a result of problems with an unknown woman and stuff in the past was of minimal probative value. Evidence that a third party appeared at a crime scene around the time of the case did not constitute substantial link between the third party and the crime. Right. Just being there is not enough. There has to be other connections. And to me, they have a lot of other connections. People walking right by where the body was. People driving to the police station, being on the phone, moving cars around. People talking about it afterwards. How they were talking about it afterwards. They have more than just somebody being in the vicinity. This court has the discretion to rule in advance of trial whether the defendant has made an adequate showing that potential culprits were connected to the crime. Defendant must provide advance warning to the court by offering third-party evidence or argument at trial, which they've clearly done in this case. And, of course, the Commonwealth thinks they should not be able to make those arguments. If I had to guess how Judge Cannoni is going to rule on this motion, I would guess that she is going to say no to the third-party culprit defense. She's going to make it seem like it is still open and say, you can't talk about it in opening, but if you present the evidence, I may change my mind. The real question is she going to tell Yannetti or Jackson or whoever's doing the opening, you can't say X, Y, and Z? Is she going to strike certain things from the record she didn't strike last time? Because I think Hank Brennan is going to be a lot more touchy and specific about these rulings, these motions, these objections than Lally was. I think he is going to be much more on it than Lally was in the first trial. All right. What's next? We never know. We're just going to find out. Here we go. The next motion. Commonwealth's motion limiting to prohibit reference to any pending internal affairs investigation, sustained findings unrelated to this case, or unfounded allegations of misconduct. Can you guess who this motion is about? I'll give you a second in the chat. Yes, I see a lot of people guessing correctly. The Commonwealth moves in limine to prohibit disclosure of reference to internal affairs investigation pending against any law enforcement witness. The Commonwealth further moves in limine. Okay, we know what this is they're doing. They want to prohibit any reference to any civil lawsuits filed against the Canton Police Sergeant Lank relating to an incident that occurred nearly 20 years ago. And we know a lot of this came out during the trial. And the defense was allowed to get into a lot of this. And it looked as dirty as it proctorably could. So Hank Brennan is going to try to clean up a lot of that, not make law enforcement look so dirty. That's his goal. I think it's a smart move. I think it's a good move. Will the judge allow it? I don't know, because she did allow this stuff in the first trial. In the federal lawsuit previously relied upon by the defendant, there was no adverse credibility determinations against Sergeant Lank or any findings of liability. The case was dismissed by agreement of the parties. Until a finding of liability has been made, a pending civil lawsuit constitutes an unsubstantiated allegation of police misconduct that does not tend to negate the guilt of the defendant. Findings of civil liability made against prosecution team members in the performance of their official duties are subject to automatic disclosure and fall within the duty of the inquiry. So basically, because the lawsuit was settled dealing with Lank, you shouldn't be able to say that a lawsuit was filed because a negative inference can be made from that. But you should be able to say, yeah, this is what you say happened, Lank, but that's not the story that the victim gives, right? And they took steps to try and fight you on that, right? There are ways you can say certain things without saying they filed a lawsuit. I tend to agree that saying they filed a lawsuit might be something that shouldn't come out at trial. It's a judicial discretion call. So if Judge Cannone doesn't allow it, I don't think it's the worst call in the world. In my opinion, all of this is so dirty that the state should have to live with the cops that they employ, and it should all come in because it paints the picture of what's actually going on in this case. But you have to also remember, a lot of this was kind of happening fast and furious the first trial, and Judge Cannone let a lot of it in. So now after time to reflect, is she going to go back and not allow the defense to really dig in as much on some of these officers? A judge, where was it? Pursuant to Graham, if a police officer's credibility is critical at issue at trial, the judge has the discretion in the interest of justice to admit evidence of specific instances of the officer's false statements in prior unrelated matters. A judge, in deciding whether to allow a police officer witness in the interest of justice to be impeached with prior misconduct, may consider the age of the prior misconduct, the strength of the evidence of the misconduct, and the simplicity of establishing it, and whether the prior misconduct is probative of how the officer conducts police investigation. In instances where there have been no sustained findings of misconduct, the jury should not be permitted to consider any allegations of misconduct where any disciplinary action is but one possible outcome. Exoneration and protection of the officer and the department from unwarranted criticism is another. So this, again, if she allows stuff like this, if she doesn't allow stuff like this, then now you're giving the benefit to law enforcement and to Proctor for kicking down the can down the road on this IA investigation. Is he going to get terminated? Are they going to have specific findings? The fact that they don't do it, if the judge doesn't allow them to talk about it because it's still open, completely unfair, completely Bush League, and an abuse of governmental power to control when and how this stuff is going to happen. So if I'm Judge Cannone, I'm just going to let it in. You let it in last time. Just, put another shrimp on the Barbie as far as the things that are piling up against Proctor. In instances where sustained findings have been issued which do not reflect untruthfulness on behalf of the officer, nor exhibit any bias against the defendant, well, that doesn't work for Proctor, by other officer against whom sustained findings have been made, the conduct is equally inadmissible and lacks relevance. Further, the Commonwealth requests advance notice and production of any reciprocal discovery relating to any specific instances of prior misconduct or false statements that the defendant seeks to introduce or use to impeach law enforcement witnesses. So what do I think Cannone's going to do here? I just can't possibly believe that Canoni is not going to allow some of this information to come in. What I think she might do is narrowly tailor it, not allow maybe some of the stuff that came in the first trial, make the defense proffer exactly what they're going to get into, and say stuff like, you can say this, you can't say that. That's kind of what I would expect. All right. Next up, let's see what we got here. Commonwealth's motion in limine to preclude reference to any alleged bad character or any prior misconduct of the witness or victim or any witness. At the previous trial, the defense lodged a slew of claims of alleged bad acts against witnesses. Indeed, the defense has engaged in a comprehensive campaign to inundate the public with its claims and has repeatedly declared or implied that the Commonwealth, the prosecutors, the court, trial court employees, and witnesses are corrupt, declaring that virtually every civilian witness, police officer, and first responder was complicit in a cover-up of evidence, and implying that nearly every witness is a liar. So what's kind of interesting about me and about this, and could be ironic, is if the judge does limit some of this, does it force the defense to go purely reasonable doubt? And is that actually a better strategy? Just something to chew on and think about. I don't understand. It's not like they're coming out of left field saying these cops are dirty. They have almost more evidence than I've ever seen in a case that don't have like cops doing stuff on video, like, beating somebody that's in custody or things like that do happen. But this is about as corrupt of a woven web as they could possibly weave. There is so much smoke to this that there is fire there. So to act like, oh, they're just lodging complaints at everybody and it's all unfounded, it's totally inappropriate, no way, shouldn't come in, judge, is not, in my opinion, intellectually honest. Such allegations have no foundation nor bearing on any issue in this case and would constitute impermissible bad character evidence. Whether during the opening statement, during cross-examination of any Commonwealth witness, during direct examination of the defendant's witnesses, or during closing arguments, defense counsel should be restrained from making such references unless obtained prior court approval. We might as well get this out at the beginning of trial. Judge Canoni's not going to allow them to do this. Major appellate issue. Not a good thing to stack up appellate issues, okay? Because that means you don't have a fair trial, number one. Number two, you don't necessarily always win when you feel like you have good appellate issues. And for them to not be able to say, it just thumbs down to myself, for them to not be able to say that there was corruption here and there was a piss poor investigation and maybe they did it on purpose. And in some of the defense's filings, they talk about how this all happened during this case. Proctor was specifically talking about this defendant. The things that he said and the things that he did make sense with how he talks about and hates this defendant. So why are we acting like this is unfair and shouldn't be allowed? A judge may properly exclude evidence that is introduced merely to show the bad character of a witness. Yeah, but if the bad character of the witness specifically relates to this case and this investigation, it's totally relevant, should absolutely be allowed, and is the only way you can have a fair trial. Further, evidence of prior misconduct may not be used to impeach a witness's credibility except by production of records of criminal convictions pursuant to the limitations and requirements of this rule. A trial judge has the sound discretion to determine whether prior bad acts evidence is relevant and whether the probative value of such evidence is outweighed by its prejudicial effect. And it is funny, based on some of the motions we read yesterday about the Aruba incident, how that they're saying is more connected to this case rather than the officers literally talking about and taking action in this case, in this defendant. The judge's determination will be upheld absent palpable error. See also these cases. The judge properly excluded evidence that the victim stole a watch of the defendant. Impeachment by a prior bad act that demonstrates lack of character is not permissible and invites misuse by the jury. No error when the judge excluded evidence that witness was not a good mother in an infant homicide case, even when the defendant claimed the witness was the real perpetrator. What I don't like about certain one-line citations is they could be very different if you read the entire case, because that one doesn't make much sense to me. I'd have to read the case. Evidence irrelevant to the issue at trial or to a witness's reputation for truth and veracity is inadmissible to impeach a witness. Any bad character evidence of infidelity, propensity to consume alcohol, or the defendant's suggestion without any factual support that every witness is a liar or participant in an unfounded scheme to frame the defendant has no bearing on any of the issues raised in this case. So again, we know alcohol consumption, drug consumption can be important when these people are eyewitnesses and they were in fact admittedly drinking that night. So that makes it kind of tough as well. Where was I here? Any bad character evidence of infidelity. Okay, we already settled that. The defense should not be permitted to introduce bad character nor specific bad acts of the victim or any witness. The proposed evidence only serves to disparage the victim's and witnesses' character and to distract the jury. So you shouldn't be able to do it to distract the jury. I feel like it was pretty narrowly tailored in the first trial, and the judge made sure of it, that it was narrowly tailored to what specifically was going on in this case. In this case. And I think that's how it should be. It should be narrowly tailored, and I think the judge should and will allow at least some bad acts, bad character evidence about the witnesses, what they said, what they did in connection with this case, or in connection with how they do investigations, how they handle chain of custody, how they handle subordinates, or how they handle dealing with their bosses, how they handle interviewing witnesses, why they interviewed witnesses that way, how professional or unprofessional they are on trips, where they leave their firearms, if they get drunk and use police vehicles. So from my perspective, I think she will, I hope she will allow this in, because it's the only way to really get the full picture. Rainey, if third party is denied, can they appeal now or do they have to wait till after the trial? They're going to wait till after the trial. Amara, I might be totally off base, but it seems wild to me that Brennan, a career defense attorney, is working so hard to protect disgraced troopers. So he's not the only defense attorney that's ever been a special prosecutor, but I would have to, this is totally my opinion. I would have to think there's some relationship there with somebody that would make him do this. Yeah, he's getting $225,000, but that wouldn't be enough, in my opinion, to, if this really is something that other people are going to look at as a real career dip for him, that's not enough money for that, that's for sure. Wafa, I agree with the cops, ESP, Proctor, especially Proctor being corrupt, but isn't all too much? Is it the 18-year-old son? Is it the dog? Is EMS responder corrupt as well? Always love your feedback. So I would say they have to present evidence of the issues. And I think the issues in the case are, there are people in that house connected to the cops. There are people in that house that asked John to come over there. There are people in that house that would protect each other if something were to happen. There are people in that house who have the means and opportunity and physical ability and professional ability to make something like this happen. If Karen Reed wanted to do this, it'd be really hard for her to, even try to make evidence appear or disappear or mess with cameras or whatever. And I'm not necessarily saying this happened, but I'm saying there's enough there for the defense to make the argument that something could have happened in that house and the cops refused to investigate it. There's a reason the defense believes factually they refused to investigate it, because of relationships. And there's evidence after the fact, text messages, meetings, issues with the evidence and preservation of evidence, that all could lead a jury to believe that something else happened here other than Karen Reed doing it. It's not necessarily saying the 18-year-old did it, not specifically saying an ATF agent did it, but it's still evidence I believe is completely appropriate for the jury to get the full picture, and the state should welcome the burden of proving that that's not what happened. And the fact that I agree with them, they can't prove it didn't happen because their own investigation sucked, that's when you have to eat it. As the government, even if you fully believe that she committed this crime and ended the life of an officer, if because of what you did, you can't prove it, that sucks. And it's something that is the burden of law enforcement and the state. Okay, I got a couple more questions here before we get to the last one, and the one I personally am most interested in myself. Western Mass attorney, thanks for the super chat. It's funny, this case has drawn a lot of lawyers. A lot of lawyers have texted me and called me about this case, just to talk about it and their thoughts on it, even locally to me. And it's nice actually to hear from people I know that are listening and watching this. It keeps me, just based and anchored to reality and not the wild world of Twitter and what people may be thinking and saying. Ronell, hi P, do you think Judge Bev knows there is a notion out there about her that she is totally biased against Karen Reed? Thanks for your hard work. It's appreciated. She probably knows. I think it's not a great thing. Like I try to still think that she can make unbiased decisions, even though some of them I think absolutely point to that and that issue. I think a lot of judges have that issue. So I'm hoping all she's saying is, forget the noise. I'm going to do what I think is right. And I hope she does what she thinks is right based on the law. Michelle L., with all these motions necessarily being argued in court, or will JC rule on some of them before next week? Will we see responses to all these? I think we'll see responses to a lot of them. I think that on the 18th, a lot of them are going to be argued. I think Judge Cannoni will rule on the papers on many of them. Probably a lot of them that she's already ruled on, if her ruling is just going to be the same, like no third-party culprit, no speaking objections. Yes, you can talk about internal affairs and Proctor's text messages and the other prior bad acts of length that already came in the first trial. If she's going to try to do the ones that are similar to what she already ruled on, maybe she won't have argument on them. We'll have to wait and see. Azam's falling asleep. Sleep well, Azam. Sweet dreams, my friend. All right, let's get to the last one here. Any guesses to what you guys think it is? While we throw Azam's super chat up here. All right, here we go. It is the defendant's motion in limine to allow lack of bias. So this to me is, I mean, I hate to say it, right? Because you guys know my feeling. I wish it would come in. I hope Judge Cannoni allows it in. I think it's the truth, and I love putting the truth in front of the jury. But in my opinion, based on the current state of the law, this is the longest of long shots for the defense for them to be allowed to get into the details they mention in this motion. But I hope and think it's possible that maybe Judge Cannoni will allow certain aspects or certain explanations surrounding the ARCA witnesses so that we give the jury a somewhat full, true, complete, and accurate picture of what exactly is going on with these experts. How somebody else, not in favor of Miss Reed, not in favor of the Commonwealth, hired these experts. Somebody else gave the reports to the Commonwealth, gave the reports to the defense. Commonwealth didn't hire these experts or pay them, so the defense had to. And here's what they had to say. And the only payment for the defense is when they come sit in that chair and talk to either the judge or the jury. That's the only time we ever paid them. There's got to be a true explanation, but let's listen to the arguments the defense makes here. Now comes the defendant, moves the court in limine to allow during her retrial reference to the fact that it was the U.S. Attorney's Office that initially hired the employees of ARCA, namely Wolf, Rentschler, and not the defense. As grounds, therefore, Ms. Reed states their retention by the U.S. Attorney's Office and not by the defense bears directly on their credibility, rebuts any contention by the Commonwealth of bias, will avoid causing the jury to unfairly speculate about the origins of their involvement or otherwise prejudice Ms. Reed's constitutional rights to due process and a fair trial. And here's the point. We don't want to confuse or mislead the jury, right? We really don't want to. So why would we allow this? Why would we allow information in that we know is going to confuse or mislead the jury? Ms. Reed wishes to clarify herein, in light of information sought by the court during recent motion hearings, that the defense was invoiced and did pay ARCA only following the conclusion of the first trial. The defense intends to comply with the reciprocal discovery obligations pursuant to the Rule 14 regarding ARCA's participation in the retrial, including its continuing duty to disclose under Rule 14 should it acquire any additional discoverable information following the March 6th reciprocal discovery deadline. All right, let's get into the factual background. On day 31 of Ms. Reed's first trial, June 24th, Wolf and Rentschler testified. Both Wolf and Rentschler said they were neither hired by the defense or the Commonwealth. They explicitly articulated that they did not have a contract with the defense or the Commonwealth regarding the specifics of their testing, did not consult with the defense or the Commonwealth. And Dr. Wolf clearly noted that ARCA employees were hired by another agency not connected in any way to the defense. Yet the jury still didn't quite get it. The particular agency was left for the jury to speculate about, and at least one member did. Again, citing what the juror said afterwards, I think it's good. Legally, doesn't hold a lot of weight. The independence of these ARCA employees, specifically Wolf and Rentschler, was reaffirmed during the motion hearings ahead of Ms. Reed's second trial. Nevertheless, these individuals, who will serve as two of Ms. Reed's most critical exculpatory witnesses, were indisputably engaged and hired by the U.S. Attorney's Office and conduct their independent review, analysis, and testing surrounding the singular question of whether Mr. John O'Keefe died as a result of auto pedestrian collision with Ms. Reed's SUV. These highly qualified experts have determined to a reasonable degree of scientific certainty that one, Mr. O'Keefe's injuries and death did not result from being struck by a car or by Reed's SUV, and two, that the damage to Reed's SUV did not result from colliding with Mr. O'Keefe. Hello, reasonable doubt. In other words, the scientific data establishes that Ms. Reed did not strike Mr. O'Keefe with her vehicle. Both Wolf and Rentschler, two individuals who were not hired by the defense to perform their testing, testified to the highly relevant and exculpatory fact that Ms. Reed's first trial and voir dire under oath and the threat of perjury. So just something else popped into my head. One of the things I'm most interested in seeing in trial number 2 is Hank Brennan's accident reconstruction expert. They better be good. They better have an explanation of how we can line all this up to where Reed's SUV hit John O'Keefe. Because without that, that's the ethical obligation I have a problem with. And it's like, how are you doing this? If he does have an expert that says that, people are going to disagree. I can understand then if you have an expert tell me, listen, I'm the accident reconstructionist, I'm the engineer, that happened. It happened exactly the way that you think it happened, Mr. Brennan, and I will go testify to that under oath. And if you trust and believe that expert, I understand the ethical basis, at least, of how he's getting there. I don't think he had it with Trooper Paul. I don't think anybody had it with Trooper Paul, and I think that's why Trooper Paul is not going to be the one answering those questions this time. If he was, I would struggle how you were to get there, then why you'd ever even prosecute this case. That's just one reason, right? Seems like the prosecution is running scared with all these motions, trying to block all these things. What are they afraid of? I don't think it's scared at all. I think it's smart. And if they can chip away at what the defense can present, their case gets stronger. I expect this prosecution on trial number 2 to be much stronger than the prosecution on trial number 1. And these motions are evidence of that. Do you think that the witnesses will be allowed to read the transcripts from the last trial? Yes, they can. They can definitely read. They have to read their own, right? Because they can get impeached from it. I still can't believe that the interviews amongst the circle were not recorded, or at least fully detailed reports created, times, those present, etc. Yeah, that's the issue. Ashley, what is the overview of your local attorneys? What are their thoughts? Ashley, their thoughts to me are, this is so simply and obviously a horrible investigation and a case riddled with reasonable doubt. That's their sentiment. I don't know if it's because they watch this that they agree with me, or if that's their own thought. A lot of them are. There are a couple that are former prosecutors. Most of them are probate lawyers, contracts lawyers, estate lawyers, not really litigators and not criminal defense attorneys as much. Government lawyers doing different things. Those are most of the ones that have reached out to me to talk to me about it. Cover the light with Lexus Light experiment. Cover the video with Lexus Light. So somebody sent me that. I haven't had a chance to look at it yet. I'll have to look at it. I can't cover it on today's video. Mrs. Parks is in the house. I think I saw something on Twitter, or somebody sent me something that I said, I called this Mrs. Pakistan or something last time. Which is, yeah, it's difficult, right? I'm thinking fast. I'm talking fast. I'm reading names fast. So Mrs. Parkson's in the house, or Pakistan, whichever we'd like to go with. I understand the possible bias about mentioning ARCA feds, but why in other cases do we see that the prosecution can parade in FBI agents to testify if it benefits their case and everyone knows who they are? Thank you. So here's what I'll say. The reason why I think this motion will be denied is we know what we think. We know what we think is going on with the investigation. We know who we think the targets are. We know what we think they were looking into and investigating and might do and might not do. And if there were going to be charges, who the charges would be against. But none of that is official. They have nobody to testify to that. They have nobody that can confirm that. So that is not actual evidence that's going to come out. When the FBI will come and testify against the defendant, they'll say, here's what we did, here's what we found, this is why we did it, and this was our conclusion. They don't have that here. They don't have, we're looking into this investigation to see if they doctored evidence, to see if there's no way they can go forward, to see if they lied about the measurement. We had ARCA do these experiments and this testing. The testing showed that these cops were lying and there's fraud in here and prosecutorial misconduct. Therefore, we're bringing charges against the prosecutors and law enforcement. They don't have any of that extra stuff. So it's speculative. It's guessing about what the feds did and why they did it. We know what ARCA did and what their answer was. We don't know how the feds used it. So that's why to try and use the fact that the feds are on Karen Reed's side is inappropriate, because we do not know that to be a fact. Because the feds won't come out and confirm that, which is not unusual. They never would in a situation like this. And especially now that it seems like the investigation is over, even less likely for that type of information to be allowed. Rebecca, you are 100% on point, Peter. Thank you for all you do. Just got home and we'll rewatch. I listened to your last one on the drive home from the ER. Proud to be even a small part of your awesome channel. God bless you and your family. Thank you, Rebecca, so much for being part of the channel and a big part of the chat. All right, let's get back to reading this. Both Wolf and Rentschler, two individuals that were not hired by the defense to perform their testing, testified to this highly relevant and exculpatory fact during Ms. Reed's first trial. Oh, we already did that. Furthermore, the Commonwealth, by its own admission, has admitted that it's not the ARCA witnesses that I have an issue with. Moreover, the Commonwealth stated that it doesn't care if ARCA gets testified at the trial. I don't care about their opinions. I'd welcome ARCA. Most recently, the Commonwealth communicated to this honorable court on Friday, February 25th, that there is a murky relationship between the defense and the U.S. Attorney's Office relative to these ARCA witnesses, and there is a very unclear relationship, as we stand here right now, between the history of the interaction between the defense and the ARCA witnesses. The Commonwealth has additionally conceded that we still don't know the relationship between the defense and ARCA. We don't know about the impact it has on the first trial. The Commonwealth has provided no objection or legitimate legal basis for not disclosing in Ms. Reed's second trial that employees of ARCA were hired by the U.S. Attorney's Office. In fact, the Commonwealth itself has articulated that there is a lack of clarity about key information pertaining to these potential witnesses. If the Commonwealth, who has been privy to the relevant discovery for months and has had an opportunity to question these witnesses during voir dire in Ms. Reed's first trial, has expressed confusion about the nature of the relationship between ARCA and the defense, then it's only logical that the jury too might be confused by the nature of ARCA's involvement without a full and complete understanding of how, why, and by whom these individuals were hired. Again, there are just certain rules. Like you can't talk about the insurance company in a car accident case in Florida that logically confuses the jury. And the jury should know about that. And the fact that they don't know about that makes them speculate. And they're probably going to think the wrong thing. Because we didn't mention insurance, this person probably doesn't have insurance, which is false in 99% of trials. But just because we mislead or confuse the jury doesn't mean that it's going to be an inappropriate way to handle it in trial. If the Commonwealth doesn't call Trooper Paul, can the defense? Potentially, usually you can't call a witness just to impeach them, but if they can find a way to get in his theory and how the state has changed their theory and how he disagrees with the state's expert, that would be interesting, right? That might be how I call him, to impeach the state's expert. State's expert didn't say anything about a pirouette. Trooper Paul, can you show as an example how the pirouette was that you believe happened in this case? Did you see the Lexus taillight video? It only has red LED lights, no white LED, even cracked. It would not show white, like Hank said and showed in the video. I saw parts of it and people talking about it. I have not watched all of it. Okay. Argument. To avoid unfairly prejudicial speculation, this court should admit the fact that the U.S. Attorney's Office hired and retained the employees of ARCA. Is this one really 16 pages? Oh boy. We're not going to be able to get to all this today. It's 14. All right, we'll give it a whirl here. Okay. Proof of bias or lack thereof directly bears on the credibility of the witness. It's never collateral. Defendant has a right to confront. They have a right to show bias. Bias is the relationship between the party and a witness, which might lead the witness to slant unconsciously or otherwise his testimony in favor of that party. We know what bias is. During the first trial, the defense was prohibited from mentioning the feds. To the extent that the Commonwealth impeached these witnesses by pointing out the material they did not review prior to performing their testing, the Commonwealth left the impression the defense improperly withheld certain materials. That's true. There was a false impression and prejudice that misreads defense by keeping relevant rehabilitation and credibility evidence from the jury. So yeah, it's like, well, why didn't they have this information? And I've heard juries say that specifically. Those lawyers didn't provide all the documents to those experts, so I trust the other experts that actually had everything. That's a problem. And I actually think that's something that could come from this motion, even if the judge doesn't allow them to talk about the feds, she should absolutely limit the bias information that she allows the Commonwealth to elicit. You can't make them seem like hired guns who were paid a bunch of money and given documents by the defense. It has to be fair and true. And they talk about how at least one member of the jury thought that ARCA was retained by Ms. Reed's insurance company, and how these witnesses are going to be unfairly discounted when they shouldn't. They already tried to say that the defense, nor anybody connected to the defense or the Commonwealth hired them, and it didn't work with the last jury. Again, I think that's good information to have. Is it something the judge is going to consider? We'll see. And guess what? We have truth on our side, because the feds did, in fact, hire and pay ARCA. So it's not like we're lying, right? And talking about them being hired by the U.S. Attorney's Office would further prevent juror confusion. So maybe there's a way. Maybe there's a way you can just say they were hired completely separately to do some testing by the U.S. Attorney's Office. And maybe you don't infer at all that they're on Karen Reed's side, that they're on the prosecutor's side, regardless. Jury is entitled to hear that they're hired by a neutral third party at the time of the testing. And they got to be careful, because the judge, I think, is going to find a way to say neutral third party without saying the feds. And they say that the jury must know the full context. And the fact that the U.S. Attorney's Office hired them is relevant and admissible. Pertinent that a neutral federal investigative body, as opposed to defense or affiliated third party retained expert, is clearly relevant. The general rule followed in this case, the Commonwealth, is that all relevant evidence is admissible unless within an exclusionary rule. And so again, the Commonwealth's going to argue this is speculative. They're going to argue that it is highly prejudicial, because it makes it seem like we as the Commonwealth are doing something wrong. M says, Peter saying we on our side. I say that usually when I'm talking about the lawyer on both sides, right? If I'm arguing as the prosecutor, I'll say we. If I'm arguing as the defense attorney, I'll say we. I do that all the time in like every case. But the only sports team I say we about is Florida State. But as the prosecutors, we would argue that the prejudicial effect of thinking the feds are on Karen Reed's side, when in fact that is not factually accurate because nobody's testified to it, is highly prejudicial. Highly prejudicial. And when we talk about the fact that that's highly prejudicial, does it outweigh the probative value of this evidence? Those are the types of arguments they're going to make. And those are the reasons I think, in my opinion, that people are saying, why would this be prejudicial? Because if the defense elicits information in a way that makes anybody think that the U.S. Attorney's Office is on Karen Reed's side and against the Commonwealth, that is an inappropriate, prejudicial effect on this information coming out. And what does it actually prove to say the feds versus saying an independent third party having no connection with the defense, no connection with the Commonwealth, has nothing to do with this case otherwise, hired ARCA, and then gave the reports? I think the judge is going to find a way to state this information without saying it was the feds. My opinion. If the new crash reconstructionist has a different opinion than Trooper Paul, can the defense bring Trooper Paul's testimony in the last trial? They can impeach the new accident reconstructionist with Paul's opinions. Yes, I would expect it to happen. Thank you as always for your hot take on this trial and these motions. Thanks also for correcting the record about Ms. Parks. Ms. Parks, you're welcome. Bev ruled that only an MD could opine on a medical cause of injury. First time, but allowing for the state this time. Isn't that proving error on her? ARCA, could they have testified more better before? There's a potential chance that ARCA may be able to testify about more. And if I was the defense, I'd file a motion to reconsider that. She didn't make a ruling necessarily, and it's not a rule of law that you have to be a MD to testify about those things. But she definitely stated what her opinion was, and she changed her opinion. And I think that's problematic, and the defense can make those arguments. But like we've talked about before, just because a judge says something doesn't make it the law. And if the law says something else, the judge can go and correct her opinion. Peter, do you think that with all of the questioning of the judge, this is not going to be an appellate issue? You were on a compilation video by another channel about Judge Bev and other lawyer frustrations. I think her errors and their disagreements, the defense's disagreements with Judge Cannoni's rulings, will definitely be a part of the appeal. Yes, if Karen Reed loses. So they go through and they say the probative value is substantially relevant evidence may only be excluded if their probative value is substantially outweighed by the danger of one or more of the following: unfair prejudice, confusing the issues, misleading the jury, undue delay, wasting time, needlessly presenting cumulative evidence. It's definitely nothing here except for potentially the unfair prejudice. That's what I would expect the Commonwealth to argue. That's why I believe the judge kept it out in the first case. We'll see if she changes her mind. They just go by explaining why it's relevant, why relevant evidence needs to come in at trial. I agree with them wholeheartedly on that. The Commonwealth has no unfair prejudice. Now, if I was the defense, I would argue, in order to get rid of that prejudice, I would argue, hey, let's say we don't know what the feds were doing. We don't know their investigation. We don't know whose side they were on, and they closed their investigation. Why don't we just say all that, Judge? That's the truth. But during that investigation, they hired ARCA. They paid ARCA. I think there might be a way to really inoculate and pacify mentioning the feds while still getting the truth and avoid misleading or confusing the jury. The defense acknowledges this is an unusual circumstance in an unusual case. Generally, witnesses who are employed by the federal government testify on behalf of the Commonwealth. The defense is unaware of any case in which the defendant has moved to preclude reference to any federal employer of a witness testifying on behalf of the Commonwealth. I already explained why that's different, in my opinion. And they're saying, because the state can do it, why can't we do it? Again, I answered that earlier in the video, what my view is on that. And they're talking a lot about how we did try to say it was somebody other than Miss Reed, but it didn't get through to the jury. It's going to cause the jury to speculate, which means it could cause confusion and it could cause the jury to be misled, which is one of the number one things we don't want to do, or at least as lawyers, it's what we say we don't want to do. Then we write all these rules, and the rules of evidence are problematic and create problems, right? It happens all the time, and it can be very frustrating. Ms. Reed has a constitutional right to present exculpatory evidence. See, and now here is where it gets a little fishy. Because if you're saying the fact that the feds hired ARCA is exculpatory, now you're potentially assigning motive to the federal investigation, what they were doing, et cetera, et cetera. I agree it's exculpatory, but do we know that? Is that reliable? That's something the judge is going to have to determine. I would say it's something that tends to diminish the state investigation, the prosecution of this case, and the fact that they hired these experts that said it couldn't have happened the way the state said it happened is all exculpatory. But can you get all of that information out without saying the feds, specifically the feds part? Whoop. Commonwealth, in seeking to prevent the defense from eliciting ARCA, initially hired by the U.S. Attorney's Office, seeks to deny her most basic and fundamental right. The fact that ARCA was hired to perform its testing and analysis by the U.S. Attorney's Office is manifestly exculpatory. This witness testimony undermines the central conceit of the Commonwealth's case. The Commonwealth cannot in good faith cite legal authority in support of its request for this honorable court to exclude exculpatory information about hiring of ARCA employees. Perhaps the most exculpatory and critical defense of this witness in this case, Dr. Wolf and Rentschler specifically were hired by the U.S. Attorney's Office. Exclusion of the evidence would materially prejudice Ms. Reed's defense. Here, however, any prejudicial effect runs entirely in the opposite direction. To exclude this pertinent evidence about the U.S. Attorney's hiring of ARCA would result in the jury deliberating with needlessly incomplete information and Ms. Reed's likely most exculpatory witnesses. Given that such individuals were hired without bias or undue influence by a third party as a part of the federal investigation, would only serve to invite the jury's confusion and cause unfair prejudice to the defense, contrary to the rules of evidence and fundamental constitutional principles of the defendant's right to present exculpatory witnesses. I want them to say exactly why the information that it is the feds, why is that exculpatory? More specifically, the fact that the neutral third party substantiates Ms. Reed's core defense is inherently exculpatory. Okay, then why can't we say it's a neutral third party instead of saying the feds? Considering Massachusetts precedent, it is permissible, particularly during closing argument, to disclose by whom an expert was retained. In fact, a plethora of Massachusetts and federal case law confirms as much. There's no doubt that the Commonwealth is going to try and make these seem like defense experts, and that's the part that pisses me off. It's like, if we can't say feds, fine, I get it. But then you shouldn't be able to try and trick the jury into thinking we found and got these experts. That's the problem. If the Commonwealth is going to be able to say, you guys, these are defense experts, look at them, they're hiring, then the defense should be able to respond maybe in rebuttal, and maybe in redirect, the court can say, Commonwealth, it's up to you. If you open the door to who hired these experts and if they're biased for the defense, then maybe I will let the defense talk about the feds in redirect. That might be what I do if I was a judge. Okay, the jury must be informed of the exact nature of the contingency agreement. Defense counsel must be printed across the witness about the agreement. Just generally speaking, how somebody's hired and who hired them is admissible. In essence, there's a deeply rooted basis for both identifying the specific terms of the retention and hiring of an expert, and there is foundational support for commenting on why a witness's credibility and here neutrality should be trusted. Finally, Ms. Reed's constitutional right to present exculpatory information includes asserting a Bowden defense. Both the Commonwealth and the defense have long had access to ARCA employees' findings regarding the death of John O'Keefe, which resoundingly point to an inadequate investigation and third-party culprit, given that ARCA employees have testified under oath that Mr. O'Keefe's death was not the result of injuries from Ms. Reed's SUV. Since the Commonwealth had access to this information, did not properly inquire of it or investigate it, the other potential suspects, Ms. Reed must be able to present evidence that law enforcement failed to pursue other avenues. I agree. Absolutely should be fair game. A Bowden defense, as it has commonly come to be known, may focus on either the failure of police to conduct certain scientific tests or their failure to investigate leads concerning suspects other than the defendant. The failure of police to investigate leads concerning other suspects is sufficient grounds for a Bowden defense. As a result, Ms. Reed should be permitted to provide the pertinent information regarding the circumstances of ARCA's involvement in the case, which led to their ultimate conclusion that Ms. Reed was not responsible for Mr. O'Keefe's death, because such information provided by a third party is crucial to bolstering her foundational defense that the police investigation in this matter was wholly inadequate and that authorities failed to investigate alternative suspects. After reading that, right, and thinking about it, I really think Judge Cannoni needs to find a way to give more information to the state to avoid inaccurate information to mislead them or confuse them about ARCA or any witness. Does everything the judge ruled on for the first trial carry over to the second unless a motion is filed? Generally speaking, yes. But if there's any question or you want any different ruling, then you should file a motion about it. But if she allowed it in the first trial, it would be a good faith basis to believe it's going to be allowed in the second trial as a lawyer. Colleen, when you say impeach a witness, is there punishment for this or just on the record? Yeah, wouldn't that be nice? If you can prove they're lying under oath, potentially there could be perjury charges, but impeaching a witness is really just hitting their credibility and then using the jury instruction and closing argument as a lawyer saying, can you really believe what they testified to? Kelly, did you see there is a new Bettero letter to CPD? I did not. On the Turtle Boy case, I assume, since that's where he's representing. I have not seen it. Honestly, I'm probably not going to be able to get to it. Just way too much going on. I'm planning on doing a video on the Lori Vallow hearing that she handled herself, and it was quite interesting. That's either going to drop tonight or tomorrow morning. But plus this case and Koberger and so much going on, I'm not sure I'll be able to get to that. Nenny, can the defense attorneys call the FBI agents who investigated the case? That's probably going to be a no-no. And the feds are probably not going to allow anything like that. It will be confidential, would be my guess. We'll have to see. Okay. I went a few minutes over. I started a little late, so it's okay that we did a little overtime. Hopefully you guys hit the like button by now. If you haven't, please do. Make sure you're subscribed. Make sure the reminder bell is hit. Fast and furious with these motions and these videos continuing this week. And next week is spring break. So I'm going to be on vacation, but I am bringing my satellite streaming center with me. So I still will be able to do some videos, probably not as often as I'm doing them here from an undisclosed location in North Carolina. But that's all we got for this one. If you guys, I saw some people commenting on my shirt. This is my Greece shirt. Whitney basically is buying everybody a brand new wardrobe. We're going to Greece this summer. So you might be seeing some fun shirts that look like vacation shirts because I'm getting in vacation mode already. But thanks for hanging out with me. You guys are the best. Until next time, I am out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a pase you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.